Talk. Talk. Talk to me Tuesday.
Hey there, welcome to Talk to Me Tuesday on a Tuesday. I'm your host, Madi B, and today I have a special guest, attorney Andrew Kachnik. Welcome.
Thanks for having me.
Absolutely. So we're going to be talking about something really exciting for our viewers to kind of get to know a little bit more and be aware of your rights. So the topic today is commissions practice, commissions fraud, your rights as an employee. It's kind of broad, but there's so many options here that attorney Andrew Kachnik is going to touch on today. I want to open up those lines of communication if you guys have any questions for the attorney today in regards and pertaining to your case. Now, I know we've already gotten some questions, so this is going to be a hot topic. We've never really touched base on this, but I think it's very important for us to educate our viewers. So let's go ahead and start off with Andrew. Tell us a little bit about yourself and your passion that you have for helping others.
Well, I'm a lawyer, and I guess I became a lawyer because I was upset with how people are fearful of the law. I think if you think about the law as a system of rules that allows our society to kind of keep humming along, I don't think that people should be, afraid of their rights. And one of the things that I did before I was an attorney is that I was a court-appointed special advocate working with sibling groups in CPS cases. And just seeing the fear of children and I guess their extended families when they go to court was something that didn't sit with me well at all, because when you're a court-appointed special advocate, you're working with the judge, you're the judge's kind of liaison on the ground, and it was just, the fear that people had really kind of angered me. And so, dealing with attorneys, kind of in the course of my job, I thought, this is something that I can do and hopefully help some people along the way.
Yeah, so we're very excited to have you, not just on the show Talk to Me Tuesday, but also a part of the team D. Miller and Associates. So I want you to talk a little bit about the topic we're speaking about today and how our viewers can relate to what we're going to talk about today.
So the topic today is just a very general overview of your rights as an employee. I'm not trying to get in depth with particular discrimination lawsuits, stuff that deals with collective bargaining agreements, et cetera, right? I mean, those are really very specific, very particular, and I guess where it stems from is we've been seeing a lot of cases recently where people were just simply not paid a commission that they earned, and that's just it's an injustice that shouldn't be suffered. And it's like people have questions, like, oh, is this can I do anything? Can I not do anything? Right? I just kind of wanted to put some general information out there, like, hey, these are your rights as an employee. This is basically what it is. If anything here sounds kind of familiar, maybe you should seriously consider seeing an attorney. Right? You don't have to see me. You don't have to see D. Miller or anybody. But just employers kind of know when they want to lawyer up, and I don't necessarily think that's clear for people on the employee side. And so I just wanted to give people a general overview of like, hey, listen, this is sort of like the legal framework governing employee relations, and if anything kind of sounds similar, you might want to think about consulting an attorney. Obviously, everybody brings different sets of facts to the table. This shouldn't be, considered legal advice. You shouldn't rely on this when making decisions about your legal rights. But if something sounds familiar, if something, piques your interest, maybe, like this would be a good time to see an attorney.
Well, that is awesome that you're bringing this to the light in regards to educating our viewers. I think with education, it allows that, what you mentioned at the beginning of the show, of that intimidation and that fear factor to kind of come down a little bit. So I think that's awesome that you're here on the show for that. So this kind of pertains to anyone that has some sort of job. I mean, we're going to kind of go into this a little bit more deeper. So, which there are different roles that are being played when it comes to an employee, an employer. But first, let's go ahead and start with you viewers that either have or have not had a job or been an employee. What is an employee in this situation?
So legally, an employee is somebody who is under a contract of hire with another person. It can either be express, meaning it's written out, or implied, but in the service of another under a contract. And an employer is obviously somebody who is in power to direct the work of an employee. And so if you have the power to direct the work of another, that's what an employer is. If you are under a contract of hire with somebody else, then that's what an employee is.
And there may be some of you guys that are either about to be an employee or currently an employee. So I think this is awesome information to kind of know. But tell me, and Attorney Kachnik, why is it such a big deal about this distinction about who is and isn't an employee, which there's different tiers to it, but why is that such a big deal?
So, I mean, the biggest deal is, when somebody else gets hurt, who is responsible? If we were just on a bus or something and I, get punched by somebody, right? Who is responsible for that? It's obviously the person who punched me. But we live in a society where, we get business services of all kinds all the time. And so basically the biggest distinction, or relevance for, what an employee is versus, I'm just, paying somebody to mow my lawn, and maybe they aren't an employee. But, for standard, employees, why is it such a big deal? It's because an employer can be held vicariously liable for the torts of their employee, which basically means, if you get hurt by somebody's employee or somebody whom you've hired to do something for you, or just somebody who's working on behalf of somebody else, not only can you sue the person who actually hit you, if they're working within the scope of their employment, you can also sue their employer. And this is a big deal because oftentimes if just some low-level employee hurts you, right? You can take them to court, but the only amount of money that you can get is however much money they have, and an employer is typically going to have a lot more money than the employee. And so that's why it's important, because when things go wrong, if somebody's an employee, right, somebody can sue your employer.
Wow, that's great information. So it sounds like what you're saying is that if an employee did something wrong, the employer can be held liable, whether it's a theft, property damage, and stuff like that.
Again, it really depends on the facts and circumstances. I mean, like, an employee has to be acting within the scope of their employment. Their employer should have known or actually knew, sort of like what was happening at the time. Because I mean, if an employee just decides to go rogue one day, right, and it has nothing to do with the scope of somebody's employment, obviously an employer, they're not going to be on the hook for that. But like if I hire somebody to change my air conditioner, right, and then my air conditioner, catches on fire and burns down my house, not only can I sue that employee, but I can sue the employer for the damages to my home. And so that's why it's really important. It's important for the people who get hurt by the employee in that context. And obviously, if somebody if you're an employee and you've done something wrong to somebody else, while your employer can get sued, your employer can also try and recover that amount of money from you.
Wow.
Exactly. So you don't just necessarily get off the hook. However, like most people in Texas, or a lot of people in Texas, are what we call judgment proof. So they have these exempt assets, and the idea is the Texas state legislature has been empowered to protect single adults and families who have assets of these variety from people trying to collect on a debt. And so if you have stuff like your home furnishings, what is it? Farming or ranching vehicles or implements, tools, equipment, books, and apparatuses, including boats and motor vehicles used in a trade or profession. That kind of stuff can't be taken away from you by law, and it's obviously up to a certain dollar amount, which is $50,000 for a single adult, $100,000 for a family, and there are these certain categories of assets that you can have that can never be taken away from you, under very broad circumstances. Obviously, if there's a child support lien or you have a security agreement, like you've signed a contract with somebody saying, okay, if there's ever anything wrong with this debt, you can come and take this thing from me, right? Obviously, then you wouldn't be covered under those circumstances. But for just a general debt, there are, like things that, people just can't take from you. And that's found in Chapter 42 of the Texas Property Code. So if you just Google that, you'll be able to see, here's a whole list of things that can't get taken away from you under these circumstances. So
wow. So if the employer does go after, let's just say the employee on that example you gave, great example of the air conditioning, there are things, not just monetary, but there's also assets that are either protected or not protected. And I know what we're talking about right now, though, Attorney Andrew, is in Texas, right? Because we have viewers from all over. Mm-hmm. So this is pertaining to Texas,
exactly.
Correct?
Yeah. Other states have similar statutes that protect people. In Texas, like one of the things that they can't take from you is obviously your homestead. And so, every state that I know of has similar laws protecting people with certain assets. The idea being, hey, even if you get into a debt, there's certain things that you just sort of need to survive. And, as a society, we agreed that, like you can't reach these types of assets. And, you just have to go and check the laws in your particular state to see what they are. But, like just a really good Google search would be exempt property state. And it's a really good way to figure out, like what can and cannot be taken away from you in a debt collection context most of the time. Again, like if a court says, hey, you owe child support in Texas, that's not, you're not going to be protected just because all your assets are exempt. Similarly, if you've signed a contract with somebody saying, hey, you can take this stuff from me if anything happens on this debt, then that you're not going to be protected just because it's a piece of exempt property. But very, in broad strokes, just exempt property state, you can see the list of things that your state will protect that are yours from debt collectors.
So information, I'm so sorry, but that information we're going to put in the comment section if you guys want to just click on there, depending on the state. Again, I want to be clear, state laws are different depending on where you reside, and also every case is different. So I recommend reaching out to someone and getting specific questions pertaining to your matter and where you reside. So I know, Attorney Andrew, we were just talking about the employee and what that looks like. What is the difference, because some of the viewers might be also the difference between an employee and an independent contractor?
So sort of keeping in line with what we were just talking about, an employer is liable for the torts of their employee, but an employer is not liable under many circumstances for the acts of an independent contractor. And the difference between an employee and an independent contractor, broadly speaking, is that an employer has the ability to tell an employee, this is how I want you to do this work. So, if I, again, like using the example of like an air conditioning service, an employer would be able to tell me, hey, this is how I want you to go fix this air conditioner. And if I were an independent contractor, basically it would just be, go fix the air conditioner. And so that's sort of like the biggest distinction there. It's whether the employer has the right to control the details of the work being performed. So that, yeah, and the reason why this matters is because if you get injured by an independent contractor, you can't go then sue the person who hired that independent contractor because they're not an employee. There's no legal relationship between the two. That being said, there are certain duties that you can't push off to an independent contractor. Mostly those deal with safety. Like I can't hire an independent contractor to defuse my own bomb and if the bomb explodes, then like I can't just say, hey, sorry, an independent contractor did it. It's like that's too hazardous and too like important that we're not going to allow the employer to simply delegate that duty to an independent contractor, because they've created they have this situation where it's like, no, you actually have to make sure that that's safe. But in just in a lot of contexts though, if you get injured by an independent contractor, you can't go and sue the employer.
Okay, so a lot of these questions may pertain to, and will specify, to the employee or to the independent contractor. However, it can apply to both, right?
I'm sorry, can you repeat that again?
The employee and the independent contractor, some of the things we're going to talk about may apply to one, but not necessarily both.
Well, just think about it this way, right? Like, a company can hire another company who supplies them with independent contractors. All an independent contractor really means is that, there's no legal link between the employer and this independent contractor, right? But an independent contractor can be an employee of another company. It's just, like they might have a much smaller company that they work for, and so if you try to sue them, they might not have a lot of money. But independent contractors obviously can be employees of the companies that they work for, like who they get their paychecks from, even though they might be independent contractors in the context of like, this is the company that I'm, performing work for.
Awesome.
So it's who has who's holding the bag at the end of the day. Really, that's what it comes down to.
Those are great examples. If you guys want to ask a little bit more questions, if you still kind of want to know the significance and the difference. But for now, tell me exactly, what does it mean when they say the term, employment at will?
So, the state of Texas fiercely guards an employer's ability to employ employees at will. And technically what that means is that your employment may be terminated by the employer for good reason, bad reason, or no reason at all. So if an employer wants to fire you, they can just fire you like that. There's no recourse that you have in an employment at will context. At any moment, you can be fired for good reason, bad reason, or no reason at all. And so it's dangerous in the sense that you don't have any real job security if you are an at-will employee. You can't recover for being wrongfully fired, even if your employer, was bad in investigating the circumstances that led to you getting fired. If you are an at-will employee, you can be fired for good reason, bad reason, or no reason at all. And so it's a very precarious situation that you can find yourself in. And so it's really good to not allow yourself to think, hey, like, I can only be fired with notice. I can only be fired, if they, like, I don't know, if I've done something wrong. If you are an at-will employee, you can be fired for good reason, bad reason, or no reason at all. And again, this is specific to Texas. Obviously, for people working in California, it's going to be very different. But in Texas, employment at will, you can be fired for good reason, bad reason, or no reason at all.
That's a little scary. If you're an employment at will, and there doesn't need to be any type of documentation or anything like that?
No.
Wow.
Again, like, your individual circumstances may, and will vary. But if you are an at-will employee, you can be fired for good reason, bad reason, or no reason at all. And really the only exceptions to that in Texas are, if the sole reason why you were fired was because you refused to perform an illegal act, right? So if there was, another reason why you were fired in addition to refusing, to perform an illegal act, it gets complicated. But, simply refusing to perform an illegal act and then you get fired, that might be a situation where you would want to consult an attorney. Similarly, refusing to, affect a discriminatory practice, refusing to sort of discriminate against other people, right? That can also afford you some protection if you're an at-will employee. So you might want to go see an attorney under those circumstances. And the biggest one is filing a workers' comp claim. You cannot be, in the state of Texas, fired for filing a workers' compensation claim. And so basically, if you don't fall into those buckets, as an at-will employee and you've been fired, you're kind of up a creek without a paddle. And it doesn't really matter what was said to you. If you don't have anything modifying that status as an employee, you can be fired for good reason, bad reason, or no reason at all. And a lot of people might have, like collective bargaining agreements, which, obviously would modify this. There's a lot of things that can kind of tinker with the at-will employee or employee relationship, but, in very broad terms, you shouldn't allow yourself to think you have more job security than you do. If you don't have a piece of paper saying, like, I'm not an at-will employee, I can only be fired for cause, you're an at-will employee in the state of Texas, and you can be fired for good reason, bad reason, or no reason at all.
So how can, when someone is applying for a job, like our viewers, they're applying for a job, they accept the job, how do they know if they're under an employment at will? Do they have to disclose that at the time of hire?
So, again, an employee is somebody who works for an employer under a contract of hire. And that's either express or implied. But either way you're working for somebody else, it's governed by a contract. And so unless you have a contract or something amounting to, like a contractual deprivation of your employer's right to fire you, for, good reason, bad reason, or no reason at all, you are an at-will employee. And that, it doesn't necessarily need to be disclosed. If you have a contract that says, hey, like you're going to be working here for 2 years, right? Then you're not an at-will employee. And so you can only be fired for cause or whatever is in the contract at that time. But you will need a contract saying, hey, I'm not an at-will employee here. And the biggest way to say that is, like the employer has to explicitly give up their right to fire you for good reason, bad reason, or no reason at all. And it can't just be, hey, like we won't fire you for, good reason, bad reason, or no reason at all. It has to be, hey, we are giving up our right to fire you only for, like good reason, bad reason, or no reason at all. So it's a weird distinction. We might have to come back to that because I don't necessarily think I gave the best explanation there. But
no, it's definitely something that we could definitely follow. Now, I know you were talking about contracts. So does most employers or all employers, do you need some sort of contract for your your position?
You just for your position as an employee, you're going to be governed by the rules of contract law, but you don't need a contract that's in writing that says this is my contract of employment. And it's been my experience that a lot of employers are wary of giving employment contracts out because, like I said, if they specify, like, hey, you're being employed for a period of time, then they're giving up the right to fire you without cause. And so that's basically, the biggest example here, which is if you don't have an employment contract, it's almost a certainty that you're an at-will employee. And so, you can't allow yourself to think that, like, oh, just because my employer said, hey, we're going to keep hiring you through the end of the year, right? Like, that doesn't mean that if they fire you tomorrow that you have any legal recourse. And so really the issue is, unless you have a contract in writing that says, like, you're hired for a term of years, or, like, we will only fire you for cause, right, then you are, by default, an at-will employee, at least in the state of Texas.
Wow. Okay, that's great information. I know we can keep building on that, and definitely want to welcome some of those comments. So tell me a little bit about what the term means when it's stated good cause.
So good cause is basically if you're not an employee at will, then you can only be fired for good cause or whatever it says in your contract. And so good cause is defined as the failure to perform the duties within the scope of employment that a person of ordinary prudence would have done. As a lawyer, I can tell you this is the negligence standard, or as close to the negligence standard as you can get. If you are not performing your duties like somebody else would under similar circumstances, then that is grounds to fire you for good cause. And so, even if you're not an at-will employee, you can still get fired. However, if you are an at-will employee, it doesn't matter whether or not you've performed your job duties as well as somebody else would in your circumstances. And, additionally, there's, if you're not an at-will employee, but your contract says, hey, good cause is defined as this, that's what good cause is defined as. So if you have to meet performance targets and that's set out in your contract of employment, right, and you fail to meet those, those targets, it's very likely that you can get fired for good cause. But if it doesn't say, hey, like you need to meet these performance targets, or we're going to fire you, then, it's judged by the standard of what somebody else would have done in your circumstances.
And in good cause, let's just say someone gets fired with the ability of good cause. Is there going to be documentation to support the quote-unquote good cause? Or they don't have to have any type of documentation, aka the employer?
Again, each set of circumstances, it's going to differ. Sometimes employers say, hey, like we're going to give you notice, and they'll put you on a thing like a PIP. But, for good cause and demonstrating good cause, it depends on how that company wants to go about proving that you didn't perform your duties to the level that somebody else did. And oftentimes, like you will need to document that. However, if there's just, if one day you come to work and, like you just, I don't know, like come to work with a bomb and, like the building explodes, you're obviously not going to need prior documentation for
Right.
firing that person. So it really depends on the factual circumstances. But, in most situations, the company is going to be taking steps to document, hey, like this is why this person isn't performing as well as somebody else would in their same situation, and because they're coming around to making a good cause argument.
Wow. Okay, so I know we have right now a question from Reginald Burns. So welcome to the show. He did say, I was fired from my job and not giving a reason. My manager called me on the phone and told me, don't come in, and I asked why. He wouldn't give me an answer. He said if I come in, the police would be waiting. I'm going to repeat that one because it's a little lengthy. And every case I know is different, but Reginald is commenting, I was fired from my job and not giving a reason. My manager called me on the phone and told me, don't come in. I asked why. He wouldn't give me an answer. He said if I come in, the police will be waiting on me.
Again, if you are an at-will employee, there's nothing that you can do, at least in the state of Texas. If you had an employee handbook that said, like, we will give you notice before we fire you, right? Even though you're still an at-will employee, you might have an action for not having notice in that situation. But there's not really a whole lot that you can do for having been fired if you're not an at-will employee. So, like, unless you had like a contract saying we're going to employ Reginald for 2-3 years, however long, right? It can't be infinite, right? We can't say we're going to employ Reginald forever because that's still an at-will employee. But if you have a contract that specifies a time length, then you can only be fired for good cause. Otherwise, you are an at-will employee, and if you're an at-will employee, you can be fired for good reason, bad reason, or no reason at all. And if the company doesn't have something like an employee handbook saying, hey, we have these procedures in place, we're going to give you notice when we fire you, right? Like, there's nothing that you can do about the firing, right? Like, because you can still be fired as an at-will employee, but you might have a cause of action for, not having notice that you were being fired. So, again, it depends on the factual circumstances of your particular situation. But that's, like, if there is an employee handbook and it does say we will give you notice or we'll tell you the reason, you might have a cause of action, but there's not really a whole lot you can do about actually getting fired.
Yeah, and if you want to give us a call, I know the phone number is on here. We can. Every case is different. It's a case by case. There's different scenarios that I know, like what the attorney was just stating, that could be depending if, so that's something that we can advise or look into at a later time. So thank you so much for that comment, Reginald. So my question to you, Attorney Kachnik, is what if someone is not being paid? What do you do in that circumstance?
So that's obviously a different, kettle of fish. There's a lot of different ways that an employer could not pay you. But generally speaking, you have to be paid, and you have to be paid promptly. So unless you're something like, a white collar worker, right? At least in the state of Texas, you have to be paid semi-monthly or 2 times a month. If you're a white collar worker, chances are your employer only has to pay you 1 time a month. If you aren't being paid, right, then your employer has breached the terms of your employment contract, and so there's a bunch of different things that you can do. But at least in the state of Texas, what you can do is you can file. You can go seek an attorney's help, but if sometimes it's too small or whatever, and an attorney's not going to take the case, and that's just a nature of the economics of being an attorney. But something that you can do, at least in the state of Texas, is file something with the Texas Workforce Commission under the payday